We're also live on Zoom now. For those that will not be able to join here, they should. Okay, so maybe I should also drop it here, the chat box. I really don't know how to pin. Yeah, let's see. So that's the YouTube link, Business Law 21. Yeah. Okay, so um, let me share my slide. Can you all hear me now? Can you hear me now? So let's start.
Yes, ma'am.
I hope you can hear me and you can
Yes, ma'am.
also
Yes, ma'am.
see my slides. All right. So how have you all been? I hope you are doing well. How's preparation for, I hope it's not, I don't want to scare you now. I hope you are preparing for your exams as well. I'm not scaring you. I'm just trying to prepare your mind towards it. And the fact that you're at home doesn't mean you won't prepare well. Can always have Zoom class with your friends to discuss and ensure you have someone that is pulling you along. So on this very beautiful day, we are going to be having the topic hire purchase. And we are going to be looking at the history and evolution of hire purchase. So like we used to do, and like we do, our chat box is a place where we communicate so that you can respond to everything. And we may not be able to call you all one after the because of the number of the class. But when you drop in your chat, your questions, your observation, I'll read and I'll be able to make comment on it immediately. All right. So please, I don't want you to write your matric number because Zoom is going to generate your attendance. And I would have loved, or if there's a question from me to you, I expect the whole class to respond to my question. That means you are actually in attendance. That suffices than your matric number. And also, like I used to say, ensure that you don't go online to search for my responses. I want you to be real. Tell me exactly what's on your mind. Remember, we're in an open class. You may not be able to go through, be able to browse through go online. So just do your best. Give me what you have, your ordinary understanding of the topic. Then I'll be able to direct you properly. What we are doing is actually beyond this class. It has to do with life general. So it's not only about the exams. The exams will go, it will come and it will go. But your residual knowledge will be the one that would help you in business. Before you can lay your hands on books, at least you have something that in your mind really that can help you when you have when there's an instance of making decision on the go. At times that you need to make decision instantly. You may not even be able to browse through your phone, because at times browsing through your phone, some people means you don't even know what you're doing. So ensure that you are here participating and don't use online to respond to my questions. And I'm sure by the grace of God, we are going to have a smooth ride today. So let's commence. What is hire purchase? Who can tell me what hire purchase is? What do you understand by hire purchase? You've been hearing, or only if you've not heard of that term before. Even if you've not heard of the term before, just look at the words and try to put it together and tell me what you understand by it. What comes to your mind? I'm expecting responses. Paying in installment. Thank you, Ayomide. Ayomide says paying in installment. Like I said, I expect 1,500 responses when I ask questions because I'm expecting to get 1,500 students here. So it is that response that stands for your attendance. Even if Zoom link would give me your attendance, your responses is enough for me for attendance. So if you are not responding or going online to give me responses, that means you are actually not in this class. All right. So I'm getting other responses. Hire purchase is transfer of possession of goods with regular installments. Beautiful. I hope that this I hope you've not gone online to search for it. Okay, Adewale says paying in installments, right? When someone buys and pays an initial deposit, then pays the rest in installment. Beautiful. I'm enjoying these responses. These are fantastic responses. Instrumental payment and all of that. Paying in installment while keeping the goods. Beautiful. These are very good responses. I'm expecting more. They're very wonderful. But I just want you to always have it and to always understand that when it comes to law, our ways in law is different. You know, and that's why some people will say that lawyers are the only learned people. I'm just saying it as an aside, okay? Because the way we do things, definition-wise, is quite different from what obtains generally in the world, or generally with a layman. A layman, you give me responses according to what you have observed. But then the fact that you have been observing that, or if that has been the norm, doesn't mean that is the requirement of the law. It doesn't mean that's what the law says. So when you're talking about hire purchase, I want you to use a residual knowledge. So that's why I will first start by using a definition that, or I would like to pair these two words together, such that even if you have not looked at your book, you'll be able to understand what I'm saying. Look at it. We say hire, purchase. What is the meaning of hire? The word hire, what does it mean? I want a response. The word hire, what does it mean? H-I-R-E. Employ, no. In this context, yeah, Ruth said to rent something. Thank you, Ruth. That is rentage, to rent. Samuel and others are saying rent, yes. Hire means to rent. This word hire is like the word that they've been using, is a very long, it is our parents, our grandparents. But then within the new Gen Zs and all of that, you see it as rent. You rented something. Rent means something that you collected, but with the view to return it, right? So then let us look at purchase. Purchase means to buy, to own that thing. Then what then comes to mind? I don't know the English word that they use for this, when opposite things comes together. To hire and to purchase. They are two different things. To rent and to buy. So what hire purchase means is that you are under an agreement to rent, but with the intention to buy. I'll repeat myself. Hire purchase means an agreement to hire something, an agreement to rent something, but with the intention to later purchase it, with the intention to later buy it. Do you understand that? Thank you, Akokota says, Queen says, oxymoron. That's good, thank you. So do you understand my explanation? Hire purchase means so like I said, hire purchase means an agreement to rent with the intention to buy it, with the intention to own it later. Yes. I hope you notice two things. The definition you have been giving me was instrumental payment to buy. What we are saying in essence is that instrumental payment is a payment for hire, is a payment for rent. It doesn't mean that the person paying it would eventually own it. But then there is an intention to own. But that payment in installment is not an absolute payment. All right? It's just a payment for rent. But then you cannot finish paying for rent and they then agree that, oh, this thing, I will buy it. It would of course have been in your It will, of course, have been in your agreement that, oh, if I pay this installmental payment, after the installmental payment, then I will own it. We call something nominal price or something. That may be something that you use to redeem that thing from the owner. Do you understand my explanation? Hire purchase is an agreement to rent with intention to buy, with intention to own. Okay? I need a response. Do you understand me? Because that's where the whole thing starts. If you don't understand my explanation, then as I'm explaining, you will not get it. But I want to get response that, oh, I'm not giving you the law term, the jargons, I'm not using it now. I'm just using the normal terms that you use in the daily, All right, so let's go ahead. So here, are you sure is there a noise here? Is there a background noise here? Your colleague said, a colleague of yours said they can't hear me. Oh, there's a background noise, really? And really affecting you? You can't hear me clearly? Wow, that's my AC. Let me work on it. Let me put it off. Okay, someone said it's not from my ends. Okay. So, can you hear me clearly now? Can you hear me clearly? All right. Of course, I can't hear any other noise, even from any of your classmates. Okay, so let's start. So here, after I'd explained the way it is our normal day-to-day language to you, this is what hire purchase is. So hire purchase is a legal term for an agreement in which the owner of the goods transfers possession to the hirer for his use and enjoyment in return for payment in regular installments. Okay, let's explain that. So what it means is that in an agreement or a contract of hire purchase, okay, we use two terms. We use the word owner and the hirer. The owner is the person who owns the thing and wants to give it out, and the hirer is the one who had the intention or who asks to have that thing, or who eventually will be paying installments.
And your time will mute your mic.
So what it means is that the hirer under hire purchase agreements would always be in the possession of the goods. Being in possession means that thing will be with them. It could be a car, it could be some goods or whatever. But then it will be in his possession while he is making regular installments, while he is making regular payments. The next point says, upon the completion of the payment, the hirer has the option to either purchase the goods or to return them to the owner. You see where the clause comes in. Now, the definition way that you all have been giving me is the first point, which says that the IRA will be in the possession and as well be making installmental payments. But the thing is that even if he makes installment, even if he makes instrumental payment, it doesn't mean he can own it later. It means that they both should have an option. He has an option. After making all the payment, he can decide not to take the whatever with him again. He can decide to return it back. All right? But then he can also decide to own it. he can decide to retain that thing with him. You know, so he can decide to retain it or return the item to the owner. Right? So what are the things that then, what are the features that you can see in hire purchase agreements? I can't hear any other person. Okay, so Oluwaseun, I can't hear any other person for me, but I hope you all can
Apologies
hear
for
me.
interrupting the class, ma. Ma, can you hear me?
I hope you all can hear me.
Not hearing me.
Okay, okay, this is what
Daniel
I will
Taiwo,
do.
please mute your mic now. You're making noise.
I think we
Exactly,
should,
like Taiwo,
one of the class
mute your
reps,
mic.
Ephraim, can you
Distracted.
send your official, Unilag email address to me so that I can make you a co-host and you can mute whoever that is disturbing your colleagues. So Ephraim, I'm expecting your Unilag email in my WhatsApp, please. Please be fast about that. Yes, I can't hear you guys, so I think I'm happy I can't hear you because hearing you will just interrupt me. You know. Someone said I should turn off. Okay, I don't know the reason why I can't hear you. It's because my volume, I put it off, it's muted. But I hope you can hear me. If you can hear me, I'm okay. So if there's a need, so you won't interrupt my class. Okay, that's better. That's better. So I'm still expecting Ephraim's your is it Ephraim or Ephraim? Is he not in class? I can't get his email address so that I can make him a co-host, or can any other class rep, please send it to me personally, a personal mail. Sorry. Okay. All right, it's gone now. Okay, I think Isaiah sent us to me. You know, it's going to take a little while because I have to go on edit. Okay, then, then give me your Unilag email address so you can have access to, you can be able to mute those interrupting us. But then, because our class is a long one today, I want us to be fast with it. Okay? So then what are the features of hire purchase agreements? What are the features of hire purchase agreement? Number one, the buyer takes possession. The buyer takes possession of the goods immediately and then he agrees to pay the total hire purchase price in installments. Okay? From the beginning, he will take the possession. He may not even have started making payment, but then he would take, the first thing he does is to take possession, and subsequently he would be paying installments. Now, notice this is what you all have told me, that of course it makes installments, but then there's a clause that had said that with the option of either retaining the item or giving it back to the owner. So the next, explaining this further says that the hire purchase, the price is the total price. It is made up of the cost of the goods and the interest. I hope you all know at this time that if you're in an hire purchase agreement, you don't expect to have a price that is sold everywhere. Because if it's going to be an hire purchase agreement, the person, there should be an interest. Because the assumption is that if such a money is kept in the bank, it will generate interest. And so you cannot expect to buy a car on hire purchase the same way you buy an outright sale. I hope that is understood. I need a yes or no. So in hire purchase, the price is the actual price of the item plus the interest, all right? Plus the interest. The next point says, So here's what the next point says. 2 says, the hire purchase agreement will usually provide that the property and the goods passes to the hirer when he has paid all the installments. So this is it. In their agreement before the hire purchase, before they commence at all. You know, of course, we have treated contract. And so in their terms of contract, in what they would have written down, they would have written down that when this person makes all the installmental payments, he retains the ownership, he retains he retains the items, and so title passes over to him. You know, title will ordinarily be it will be with the owner, even if the possession is with the hirer. All right. But then in the contract agreement, it will be prepared. The agreement will be prepared in such a way that it will state that after you have made all the installmental payment, then the rights, the title in the item will pass over to the hirer, except there are some times that such an agreement will then include that after he had paid all the installmental payment, he still had to pay some nominal payments. So that nominal payment is just like a little amount of money to redeem that thing. So they could say, oh, the installmental payment is 50,000 naira monthly. But then he's expected to pay like 20,000 naira as a nominal payment. This means that he's saying with this 20,000 naira, I'm telling you that I want to own this thing. So what that means is that some people may even, after making all the installmental payments, remember the installmental payment is not the payment, it's just a rent. So you can then decide that, oh, after the installmental payment, I don't want to own it. Please take it back. Although in this part of the world, it may not happen in such a way. After you have taken your time, you have done a lot of things, you have sacrificed, then when it's time for you to own it, you decide to give it back to the owner. So most of the time, a lot of people will pay the nominal payments. So it's not in all cases that this nominal sum comes in. But in the case where this nominal sum is written in the contract, then the hirer would have to pay the nominal sum. And like I said, the nominal sum is mostly like a certain amount of money that's mostly little amount of money just to redeem or to be the owner of the hire purchase agreement. And remember, if there's anything that seems is not clear to you, ensure to put it down in the chat box so I can address it as I'm having the class, okay? So what then are the features of hire purchase? Number 2, I think we have explained 2 of them. We explained the fact that possession is in the hire, and that number 2, that it can decide to own it later. So the third one says, each installmental is treated as hire charge. Each installmental payment is treated as hire charge. So what it means is that each installmental payment that this person makes, right, it is treated as if he's paying for rent. He's paying for the rental of that item. It's not as if he's paying to own it. All right? It's just as if he's making, that payment is as if he's renting that item. And so it is seen as a rent charge. It is seen as a hire charge. All right? The fourth one says, the hirer can decide to terminate the agreement anytime, even before he owns it. So someone said, so what is the use of paying it? You're paying it because, remember, there's an agreement. The agreement that you have prepared that, oh, after I have made all this payment, I want to own it. The reason why the law gave this number 3 is such that the hirer will not have seen himself as the owner of the item at the inception. He can only be seen as the owner when he had made payments and when he has fulfilled all the obligations. I hope the person who had asked that question understood now. So number 4, we said that the hirer can decide to terminate the contract at any time before the ownership passes to him. Although this we are going to enumerate better later in our class, but then that's the position of the law. Number 5 of the feature says that on completion, even if an IRA has finished making payments, he has the option to either buy it or not. Like I said, he can decide to say, oh, I don't want this thing, please take it. So Dowda says that, does it mean that the IRA can either make the nominal payment or not? Yes, and that's what number 5 is saying. It can either make the nominal payments and it may make it. And remember, like I said, it is not in all cases that these nominal parties may decide to write nominal payments. Some people may decide to use the nominal payment. Some people may say, oh, just your instrumental payment suffices. Immediately you finish making the payment. So Eyere says that the IRA refunds the money if it terminates the contract. Will the IRA refund it? What money? Or do you mean the owner will refund the money? No, the owner cannot refund the money. If you decide to say, I'm not doing it again, that's it. Remember, the money cannot be refunded because it is treated as if you are renting it. So if a month had passed and you make the payment for that month, that payment you made is for hiring that item. So the owner cannot refund that money because it is seen as an hire. It is seen as a rentage. I hope this is clear, Eyere. Okay, so let's quickly move to our next slide. And the area we have make profits. Some people will have make enough profit, Daniel. Yeah, some people will have make profit. So 3 says that the owner will forfeit the amount already paid. No. This is to say that there's nothing like forfeiting here. Which says 3 says? 3 says this is so that if the IR defaults in making payment of the installment, the owner can exercise his rights to repossess the goods. Please don't take us back, Richard. Okay? There's nothing like that. Remember, they says, I want you to read it clearly. It says, this is to say that if the IRA defaults in making payment of any installments, the owner can exercise the right to repossess the goods from the IRA. Now, the IRA is the last person we mention here, a comma. It says, who will forfeit the amount already paid? The IRA forfeit the amount that's already paid. I hope that is clear enough. Please, try to read so that we won't go back, please. All right, the next one, let's quickly go to our next slide. Please, at this point, are we moving together? Are we on the same page?
Yes, ma'am.
Okay. Yeah. Okay, beautiful. So I saw a question there, and I know I've answered that question. Please just try to listen to me carefully. So this next point talks about the hire purchase being distinguished from other legal transactions. So there's something about hire purchase. It looks like some other transactions. So from the inception, I like us to clear all doubts. I like us to clear everything that can just stand as that can stand on our way of understanding what hire purchase is. So number 1, hire purchase and hire. So hire purchase is different from an hire. Remember, like I said, an hire is like a rentage. So if you say you are renting something, it's different from hire purchase, although it is a bit similar, but that is not the intention of the law. From the inception, it is treated as an hire. But towards the tail or at the end of the transaction, it becomes a purchase. All right? So it looks like an hire, but it's not an hire. Because in hire, you will just rent, take possession for a while, and return. I hope that is clear. Yes, someone said a loan. Of course, it's also different from a loan. All right. So in the case of hire, there is no option to buy at the end of it. You just hire and return. All right. Yes, Ayomide, there's an intention for that from the inception of the contract, right? So let's look at the next point. The next slide says that we should then distinguish hire purchase from sales agreements. You know, there are some sales agreements that actually look like hires as well. It looks like hire purchase because it involves instrumental payments. For example, we have credit sales. We also have conditional sale. And here we mentioned that once the sales agreement is made, in sale agreements, the buyer is under the obligation to buy the goods. I will repeat myself and clear this place. Remember, we said under hire purchase, the hirer only has an option to purchase. But the sales agreement, it doesn't have an option. In fact, he has an obligation to purchase the goods. He has an obligation to buy the goods. So unlike the hire purchase agreement, where the hirer has the option to purchase or return the goods to the hirer, to the owner now, okay? In the sales agreement, it is the owner. In the sales agreement, the buyer has an obligation to buy. All right? He has an obligation to buy. So let's now look at what I mean by credit sales and conditional sale. Are we together? Are we together? What I mean is, are we on the same page? Okay then. So let's look at these sales, these conditional sales and credit sale. Sales differ from hire purchase because hire purchase, unlike hire purchase, the buyer does not have an option. We have explained that. So what then is credit sale? Credit sale is when a buyer buys an item on credit. And then their agreement from the inception is that, oh, take these items, you go with these items, but then you'll be paying me. What it means is that from the inception, the buyer takes the title. He doesn't take possession. In hire purchase agreement, it is only possession that the hirer takes. He doesn't have the title. But when it comes to sales agreement, from the inception, the title had moved to the buyer. All right. And so then he would then be making installments. Now, the clause is this. During a credit sale, the buyer do not have an option to opt out, just like it is in hire purchase agreement. In hire purchase agreement, the hirer can, after he had made 50% payment, he can say, oh, I don't want to do it again. But in credit sale, you cannot make half payment and say you are not going ahead again. No. The creditor, or would I say the seller, has the option to sue for the payments, for the payment that is yet unpaid. Yes, I meant, yes, that is it exactly. The EE, that's what I mean. I mean, in credit sale, the buyer takes possession from inception. And like we said in hire purchase agreement, the hirer only take possession. Okay? It is at the end of the transaction that it takes title. So in credit sale, the buyer takes title from inception. But in hire agreement, in hire purchase, it is at the end of the transaction that the hirer takes the title. And then the buyer under credit sale did not have an option to opt out. He must make payments. So I hope I've been able to differentiate that so you are not confused. Although there is something, it looks alike by the instrumental payments and all of that, but it's quite different. So let's now go to conditional sale. In conditional sales, there is a condition. The condition could be that, oh, as the buyer, I'm going to be with these items until you have make payments. When you make payments, I'm going to give the items to you. Or it could not be it could be that, oh, please I'm going to give you something in exchange. And until I've done that, you retain the goods. So the goods title remains with the seller in this case, because most of the times the seller will hold on to the item. They mostly hold on to the item, right? Until the purchase payment is made. And also in some case, if you are giving the item to the buyer, the title in the item still belongs to him, right? Until under condition. The condition may not, it doesn't necessarily have to be instrumental payment. It could be any condition whatsoever, all right? But then it is not the same thing as hire purchase. It is not the same thing as hire purchase, although it looks similar. But then the difference is that the seller in conditional sale is committed to purchase the goods. And so just like the saying in credit sale, it does not have option to return the goods without consequences. There will always be consequences. It doesn't have option to return the goods. Are we on the same page? Are we still doing well together? So we've been able to differentiate or to distinguish hire purchase from credit sale, and from conditional sale. I hope we're on the same page with this. So let's quickly move to the main gist. The main gist why we are here. After we have cleared all out everything that can stand on our way. So what then are the legal framework for hire purchase? What I mean is, what are the laws that support it? What are the laws that provides for hire purchase? So you said conditional sale is not, Dada says conditional sale is not clear enough. In conditional sale, right? The item will either be with the seller, or even if it moves to the buyer, just the title is still with the buyer. But then, sorry, the title is still with the seller. The title can only move to the buyer after he has fulfilled some conditions. After he has fulfilled some conditions, right? The condition could mean that, oh, is until you have you send some vehicle, some things. A lot of things can, but then it is not the same thing as hire purchase agreement. Okay? Right? So just to be clear, in agreements in these conditional sales, I will repeat myself. The title in the goods, it remains with the seller, although that good may have moved to the buyer, just the way it is in the credit sale. But then, it's until the purchase price has been fully paid and the buyer has complied with the other conditional sales. There could be other conditions. And the conditions could be, for example, if you must buy from us, let's say, for example, in healthcare and all of that, if we must totally give this thing to you, it could be that we need to know that you are a certified pharmacist before we can give these items to you. Or even if you are a certified, we need to know, let's say, for example, we need to know that your account is rich enough, that you have your account is credit worthy before we can give this to you. And so you would have to go and do some things in your bank to fulfill that condition before they can move that thing to you. So what it means in essence is just that there's a condition that would warrant them to send the title to you. Okay, so that's just it. I hope I'm clear enough. And so I've given an example of maybe there are some issues, some cases. Let's say, for example, Mr. A wants to get buy some goods or want to get some goods from Mr. B. And the agreement is that this good costs 50 billion naira. And Mr. A only has 20 billion naira now. The condition could be that we like that your account, or you open you create an account for us where it will be seen that you will be crediting that account on our behalf. And so if you don't credit this account, then there are some things, we have the tendency to sue you to court and sell some things and all of that of yours. I don't want to take too much in this conditional sale because that's not why we are here. Okay? So let's quickly go ahead, right? So what then are the legal frameworks for hire purchase? What it means is that what are the laws that provides for hire purchase? What are the legislations? What are the things that legally can bind an hire purchase agreement? Number one, we have the principle of common law. I know by now you know what common law means. You did that in your first topic. And number two, we have the Hire Purchase Act of 1965. Now, before the Hire Purchase Act of 1965, there was never any act, there was never any law that regulates hire purchase agreements. So the only thing that regulates hire purchase agreement was common law. And remember, common law, what it means is that those law that they brought to us from British, that Britain brought to us, and that's what we're using, even till 1965, 5 years after our independence. So before then, it is the common law. And you know something about common law. Common law can be somehow strict. And so people have been moving around doing their contract on hire purchase based on common law. Then we also have some laws that also we've been using to, when it comes to hire purchase agreement, that's the Sales of Goods Act. That's when it has to do with goods. So if it has to do with implied or implied terms, it is the sales of goods that will determine it. When you have some by sales, hire purchase by implied terms or hire purchase by conduct, it is the sales of goods that deals with that. Also, we have the Consumer Protection Act. This has to do with the consumer part of it. That means this at that point, before the Hire Purchase Act, this Consumer Protection Act has been there to protect the consumer, to protect the hirer in case of when their rights are being infringed on by the owners now. Now, I also want to put that to you that under the common law, it seems as if the owner has a lot of power residing in them. They can do and undo at that time. All right. So then comes the Hire Purchase Act of 1965. Now, Section 1 of the Hire Purchase Act regulates hire purchase agreements generally. And what it says is that hire purchase price should not exceed 2,000 naira. Any goods that will be in hire purchase, it should not exceed 2,000 naira. And he also mentioned that Hire Purchase Act will also conduct any contract on hire purchase in respect of motor vehicles. Do you have any question? I'm expecting to get questions. I'm expecting to get concerns with this provision of the law. Do you think this should still prevail? 2,000 naira. How much is 2,000 naira now? Yeah. So what are your views? What do you think should be done? So Queen Akokota says you don't understand. What this act means is that till now, if there's anything that you want to do on hire purchase, that is not vehicle, that is not a car. It could be that you want to buy a fan on hire purchase. You want to get a clock, a phone on hire purchase. You cannot, because it has exceeded 2,000 naira. So I'm now asking, what do you think should be done? As a student, what do you think should be done to this law? Yeah, thank you, Miriam. This law ought to have been reviewed by now, but then it hasn't been reviewed. Although some people have been using some other laws, especially sales of goods, consumer protection, to hang in there, do some things, you know, and all of that. Yes, thank you very much. Onyechi also and some other people said the law should be reviewed. And so like I used to say in my classes, you know, in my classes, I see lawmakers, I see leaders in different phase of life. When you get there, ensure that this is visited. Ensure you come back to the universities and look at thesis, look at projects that can enable you review these laws. Okay? So let's quickly go to our next slide. Our next slide talks about hire purchase agreement generally. No, now we are here. Now we have started hire purchase proper. So in a simple contract of hire purchase, we have two persons involved. We have the hirer and the owner. We have the hirer and the owner. In some cases, the hirer can be seen as a seller or a financial company. It doesn't mean they are sellers, but they can be seen. You may see them as a seller. But then, to be on the safe side, I would like that you just see them as a finance company or an entity on their own. An entity on their own. So, in some cases, we also have some people called the supplier or the dealer. With the supplier or the dealer, what this means is that there are some times that we have some people, some dealers, they actually want to, they know people to supply these items to, but then they don't have the financial capacity. So most of the time, this supplier or dealer, they involve finance homes, finance companies like banks, insurance company, and all of that. So when they involve these companies will make payments. This finance or company will then make payments, right? And at that time, the finance company becomes the owner, all right? At that time, the finance company becomes the owner. And this happens because most of the times, they do not have the commercial convenience to do it. So then they involve a financial home, a finance company rather, like banks, etc. Do you understand me? Are we on the same page? You now know that we have the owner and the hirer. All right, the owner can be a finance home. Somebody said no. Now I'll repeat myself. I said we may have a case of a supplier or a dealer. Now, most of these dealers, they know people. They are here. They know people that they can give these items to. But they do not have the financial capacity to outrightly buy those things from those that sell it. And I think at this point, in order to make it better for you, let me remove this seller so you won't be confused. You know, we have some people that sell and some people are dealers. What they do is that they know this business very well, but they don't have money. So what they do is they involve financial companies. And the financial company then make the payments. And at that point, the financial company becomes the owner. All right? The financial company at that point becomes the owner. All right? So I don't understand. Okay, Chuku says, I feel it should be higher purchase. I don't understand you. I am still explaining higher purchase agreements. I am not going outside of higher purchase. I am just saying that, this higher purchase agreement, it can go in different ways. So that when you see it in these different ways, you are not confused. We can have 4 types of people. We can have 4 different personality in higher purchase agreements. We can have the owner. We can have the dealer. We can have the hirer. And we can also have a guarantor. No, you can't come the financial company is not the intermediary. Okay? Ogunlaja, Ogunlaya, or let me say Ololade. Ololade, the financial company then becomes the owner. And the dealer becomes the intermediary. And most of the times, the dealer will then becomes a guarantor for the hirer. Because the financial home will like to always ensure that the dealer is around in any, because they will be a guarantor for the hirer. The dealer becomes a guarantor for the hirer. They are still there because they are the intermediary. The finance home becomes the owner. Although they may not be the one that started the whole process. Most of the times it's dealer that start the whole process. They then approach the finance home and the finance home make payment for the thing, and then the finance home becomes the owner, right? And so the dealer or the supplier becomes the intermediary, and also we call them guarantors because they have to stand till the higher purchase agreement is concluded. Is this okay? Can we keep going? Can I keep going?
Okay, ma'am.
Don't be confused, okay? All right? It's not that technical. It's just the reason why we are explaining this is such that when you see things like this outside, you are not confused, right? You are a student of this thing of higher purchase, in higher purchase agreements. And so when you see things in diverse way, you should be able to know, oh, this is still higher purchase, although there's one other person who had initiated the process, who is no more the owner, is just an intermediary, is just a guarantor. Somebody says, so the financial company becomes the buyer. Remember, we are not doing buying and selling. The financial company becomes the owner because they financed it. So, I need to clear, I think we are not going to deal much, but I need to clear this place. This place needs to be very, very clear. The easy buy scheme, it is an hire or credit sale. So this easy buy scheme, I really don't know this. I'm not involved in it. So I don't know about this easy buy scheme. I don't know, what would help you determine what something is the contract, the paper that they had entered into. What is it that they wrote down? Did they write it down in the easy buy that when this person defaults, we are going to collect the thing they buy from them? If it is that we are going to collect it back from them, then it is higher purchase. But if it is that we are not going to collect it, we are going to sue them and collect our money, that is credit. That is credit. I am still here, taking your questions, because I want us to be clear here. I want you to be clear. They only collect money. They only collect their money. Oh, hey, if they only collect their money, that is a credit sale. Is a credit sale. It's not higher purchase. I'm still waiting for questions because I want us to clear here. We have a lot of things to do. So easy buy, the buyer drops a deposit, then collects the phone and pays the balance. They don't return. Yeah, that's just it. So that is a credit sale. Easy buy, if this is it, that is a credit sale. The dealer then becomes, yeah, in this case, the dealer then becomes a guarantor. Then the finance home becomes the owner because he financed the agreements. They are called financial homes. He only financed. And so they own it because they have made the payments. But then that dealer cannot go anywhere. He has to still be in that agreement. And so he becomes a guarantor. And remember, you know what a guarantor does? Wherever the IRA defaults, it is now the dealer. It is now the guarantor they will now start holding. They will hold the guarantor whenever the IRA defaults. Okay? Okay, so I think we are okay with easy buy. So the finance home company buy from the previous owners. Let's just remain, you know, like I used to say, okay? There's when we are doing in contracts, there are some terms you use, I would say in law, there are some terms, that's why there are some terms you have to use in some contracts. You should not use some terms. I don't want you to start using buying, selling here, no. All right, although you may see it here, but then I want you to just please use my terms. Okay, I would not confuse you in exam. I will never confuse you. I will not confuse you. So it meets the finance company to buy, to finances. It meets the finance company, of course, to buy. Invariably, it meets them to finance the company, to finance it, yes, to buy it. Thank you. Are we good? I'm moving to the next slide. The instrumental payment is remitted to you. It is remitted to the finance home. To the finance home. The money is remitted to the finance home, not the dealer. The dealer is now a guarantor. So the finance company becomes the owner, and then the dealer becomes, no, the dealer becomes the guarantor. The dealer becomes a guarantor. Remember, the guarantor will still, the dealer, the IRA is still an IRA here. It doesn't change. It will be big, it will be giving the money to the finance home. So if there's a problem, what the finance home will do is then the finance home will sue. Of course, there's in most cases, they collect the items back. They collect the items back. Okay, it becomes an intermediary. Okay, I think I'm going forward now. Yeah. So I'm trying to look through these messages to know. The commercial inconvenience is that the dealer does not have the money. It is usually commercially inconveniencing for the supplier, in some cases, to provide the credit. He doesn't have the money. So the supplier now calls the finance home to finance the business. Then the finance home then becomes the owner. Who is the dealer? Hey, my God. The dealer is the intermediary, the one that brought the business to the finance home. Please, I want you to get this thing clear. So a man wants to buy a Toyota car. The owner, the dealer, asks for 2 guarantors in his contract. Who is the guarantor? I don't, you only provide 2 people. He only said he buys. You didn't tell me after buying it, he has intention of giving it up for hire purchase. You didn't tell me that. So it's just like Mr. A being the dealer brings Mr. B. Oh, okay, so let me screw up. So Joker says, so it's just like Mr. A B, the dealer, brings B to hire keke from the finance company. Finish. Yes, thank you, Dorcas. Yes, that's a good position that you are. So Oliver says, a man wants to buy a Toyota car. The owner, the dealer, in bracket, asks for 2 guarantors. In this contract, who is the guarantor? Remember, Oliver, in this scenario you have given me, you call the owner the dealer. In this case, if a man wants to buy a car and he wants to give it on hire purchase, he's free to give it on hire purchase. But the problem is where he cannot fund it, where he doesn't have money, but he has the business acumen. Then if that be the case, he can approach a financier. That is the deal. Now, what it means is that he's also going to make profit from this thing, though. He's also going to make profit. It's not just they just come and buy and just he dumps it on the financier. He's going to make profit from it. All right.
What did she say?
Okay. So I think we should
This
go on
what?
so that I'm able to finish this
Are you
thing
serious?
before we conclude, okay? We will realize after the payment has been made, then of course it's going to have a separate agreement with the finance home on how it's going to be paid. It's going to have the intermediary who is now the dealer, who is also going to be a guarantor. Is going to have a separate contract agreement with the finance home on how it's going to be paid his profits.
Talk more of them.
I hope that is understood. I hope that is understood. Okay, so I'm going on. So what I would do is that if we are able to finish on time, I would like us to unmute at that time. Then we'll be able to rub minds together. You're able to ask questions, and I'll be able to understand you better. Okay. So let's just go on to the next slide. The next slide says, where the dealer cannot provide the necessary credit to the hirer, it can involve a financier, and that's what I've just explained. And the next point says the supplier or dealer sells the goods to the finance home, and he arranged for the finance company to supply it to the buyer. Okay? The finance home is the one that is now in direct contact with the hirer now. Okay? So, due to the complex nature of hire purchase agreements, okay, due to the fact that it can be complex, the party providing credit usually requires the hirer to also provide another guarantor. So most of the time, you normally have 2 guarantors. The hirer has his own guarantor. I mean, in the case where there is a dealership, the dealer becomes a guarantor. But where there is no dealership, where it's just an entity, a person like you have a car, you bought a car and you want to give it out on hire purchase. It is only the hirer, in this case, you don't have an intermediary, you don't have a third party. You just give it out for some other person to hire. So in this case, the hirer provides a guarantor. But where there is an intermediary, a dealer, the dealer becomes a guarantor as well. So we have 2 guarantors in a situation where there's a dealership and where there's a dealership in there. Are we on the same page? So first, let's go to now, let's now treat this relationship one after the other. We have a relationship of the owner, who then becomes the finance home and the hirer. Okay? We also have the relationship of the owner and the supplier. The relationship of the hirer and the supplier. We also have the situation of owner and the guarantor. The owner and the guarantor. Okay, so So like I've said earlier, the relationship between the owner and the supplier or dealer arises in situation where finance home or where finance company is involved. So Oliver, this is a time for you to listen very well so that you can grasp all these things very well. So I would like to also read out these points so that all of these things will be sorted out. Number one, the relationship is that of a buyer and a seller. That is relationship that governs is sale of goods. In this kind of things, sale of goods law would then apply. So in some situations, the supplier gives the owner a warranty, e.g., the quality of goods is in conformity with the requirement of the hire purchase agreement. Okay? Remember in this case, the owner is who? I want to ask. The owner, where a supplier is involved, the owner becomes who? I'm asking a question.
Company. Finance
Thank you very well. The owner becomes the finance owner. Please, if you can clap for yourself, I need you to clap for I need to see that emoji. You guys are doing well. Thank you very well. Thank you. So the owner then becomes the finance home. Our next point says, in some situations, the supplier gives the owner a warranty that the quality of the goods is in conformity and so on and so forth. The next one says, the owner might require the supplier to enter into an agreement with him. He undertakes to repossess the goods from the owner if the buyer defaults. So in the case where the IRA defaults, the finance home will from the beginning say, come, Mr. Dealer, come and sign this paper, that where the IRA defaults, you will be the one that will make payments. There could be situations like that. Okay? So that's where the dealer becomes a guarantor. He gives his words that don't worry. The goods I'm giving to you is perfect. And if this guy refuses, the IRA refuses to pay, I'm going to make payments. The next point says the dealer can be treated as the agent of the hirer. I will repeat. The dealer will be treated as the agent of the hirer. With the purpose, it will be the one that will deliver the items to the hirer. Okay? It is now, in this case, like financial module, they make sure that the dealer is still in the picture. The dealer will be the one that would give the goods to the hirer. They involve the hirer in the whole thing, all right? They involve him. In fact, he has a lot to answer to. And this, this is another business that another people venture into, you know. They venture into it because, of course, if a finance home is involved, if you have prepared all your papers intact, it's very beneficial, okay? So let's look at the second relationship. The second relationship says that is a relation between the supplier and the hirer. So in this case, that means the finance company is involved, all right? So if the finance company is involved, the relationship between the supplier and the hirer will be that of a seller and a buyer. That is governed by is also governed by the sales, by the goods of the Sales of Goods Act. So where the finance company is involved in the contract, the agreement between them is that the supplier drops out of the scene. Okay? He is not a party to the hire purchase agreement. Like I said, he will not be a party to the hire purchase agreement. He is only a guarantor. And so a lot of the time, he has a different agreement with the finance home. That in case this person doesn't pay, I am going to pay it. But then the only parties that we will see here is only the finance home and the hirer. So the hirer is induced to enter the contract by the dealer false statement. Okay, so let's read from here. There might be a different in this case. Where contract between that's the contract between dealer and the hirer. The hirer was where in cases where the hirer is induced to enter into a contract by the dealer's false statement, is liable to the hirer for damages. Okay, it will be in this case where the hirer where the dealer makes false statements to the hirer, the dealer takes responsibility for any defaults. Okay, this is just an aside. Okay, in the case of false statement, the IRA takes responsibility. Sorry, I'll repeat, not the IRA. The dealer takes responsibility. I hope I'm not confusing you. Are we still on the same page? Please don't be confused out there. It is simple. All right? The relationship between the supplier and the hirer. It's now seen that the supplier buys the items for the hirer. It's the Sales of Goods Act that then treats whatever that is happening between them. But we now say, let's say, for example, the hirer now make some fraudulent things. Okay? You remember, this is a third party, is a tripartite. We can't really say tripartite. It's an agreement bit where there used to be a supplier. Remember, it is now the finance home that becomes the owner. So what this place is saying is that where the IRA now sees a default, where he notices the fraudulent activity, it is now the supplier that will make the payments. Because at that time, because of the fraudulent activity, the IRA will not be paying again. It is now the supplier that makes the payment to the finance home, who is now the real owner. I hope those that are confused have been cleared. Who is the dealer, finance company, guarantor? Oh, Jesus. All right. Please, let's keep going because this had to finish today. Okay? So what then is the relationship between the owner and the guarantor? What is the relationship between the owner and the guarantor? We have two guarantors here. The IRA guarantors and the dealers under the recourse agreements. Okay? So the guarantor may be made a party to the main contract. The guarantee agreement must comply. Yes, thank you. Thank you for helping me explain to Ishaoluwa. Ishaoluwa, please, I hope you're understanding me. Maybe I'll be able to do more of the clearing, but then let's just keep going because we need to keep moving, okay? So don't be confused. You should not be confused. You just have to open your mind to these things, right? Now, let me try to explain. Remember, we now have 4 personalities now. Who are the 4 personalities that we have? Those that are confused, I need you to give me the 4 personalities, the terms that are confusing you. Give me the 4 personalities. The recourse agreement is that agreement that says that if the hirer did not pay, it is the supplier that will make their payments. That's a separate agreement with the finance company and the hirer. It's called a recourse agreement. Okay? Thank you, Damilare. In this, the 4 people we are mentioning here now, we mentioned the owner. We mentioned the dealer or the supplier, number 2. Number 3, we mentioned the hirer. Number 4, we mentioned the guarantor. These are the 4 personalities that we mentioned. And the reason why we mentioned them is that in most hire purchase agreement or in some hire purchase agreement, you will see these people. Now, let me start by the owner. We say the owner can be a finance home or they can be an entity, just a private person. In the case where it is a finance home that is the owner, that means there was a dealer involved. Or we call them dealer or supplier. The names is used interchangeably. In the case where a dealer is involved, the dealer has, is somebody that he conceived a company, he conceived something. And the thing is that I have some cars that I want to give out, or I have some cars that I'm selling. But because I don't have the capacity to give out these vehicles now, I need the money. So what I want to do is this. I'm going to get some finance home involved. Then the finance home will give you money as a dealer. You will buy all these cars as a dealer. You use the money of the finance home to buy the cars. The finance home will finance the dealer. As they have financed the dealer will then look for an hirer to give it to. If he gives it to the hirer will bring a guarantor to stand for him, that wherever he defaults, the guarantor will pay for him. Now, also to the owner, who is now the finance home. The finance home also will be telling the hirer, the dealer rather, come, I also want you to be in this scenario. You are going to sign a recourse form with me. The recourse form means that where the hirer that you have brought refuse to pay, the payment will turn to you. You'll be the one that will give me the money. So you also are going to be a guarantor in this case. So we say we can have two guarantors. That means the dealer, guarantor one, and the guarantor coming from the hirer side. I hope I've been able to clear these things. Thank you, Boluwatife. The hirer has nothing to do with the recourse agreements. Okay? So let's keep going because we must finish this thing today. All right? So that's just it. Then what is then is the formation of hire purchase agreements. After we have explained those four personalities, what then is the formation of hire purchase agreements? Under the common law, the hire purchase agreement can be in writing or in oral. Under the hire purchase agreement, we are talking about the hire purchase agreement, okay? Please, under the hire purchase agreement, number one, the common law does not prescribe a specific form of hire purchase, the way it should take. The common law, under common law, it may either be written or oral. Under common law, hire purchase agreement can either be written or oral. So under common law position, hire purchase agreement, for it to be enforceable, there have to be some requirements. So for under common law, there have to be some requirements before hire purchase agreement can take place. So remember, we are in formation of hire purchase agreements. So for the formation of hire purchase agreement, the common law did not prescribe any formation, any way it should go. And that under common law also, there are some things that had to take place for hire purchase agreement to go on. Number one, which is in section 2, subsection 1. Now, I'm talking about the hire purchase agreements, not common law. Okay, under common law, the hire purchase agreement can be oral or written under common law. But under the Hire Purchase Act, it must be written. under the Hire Purchase Act, an hire purchase agreement must be written. Are we clear? Memeso, I didn't get your name clearly. I hope you are clear now. So, they said it must be written unless the IRS selected the goods, and that if it is written, the price must be in it, it must be signed, the mode of the agreement should be inside, they will state the price, and also in the agreement that they have written, they must write the instrumental payments, how much will be paid instrumentally, when the deposit will be made, how it will be made, the rates, the amount, and the date that the instrumental payment will be made. All of that is meant to be in the hire purchase agreement under the Hire Purchase Act. Okay? Under the Hire Purchase Act. Also, under the Hire Purchase Act, an agreement to be treated as hire purchase, it must possess the essential characteristics of hire purchase agreement. Number one, they agree to let it out. Agreement to hire, not to sell. It can become agreement to sell or to buy at the end of the agreement. All of this we have made. They only have option to buy at the end of the agreement. So other provision says that hire purchase agreements under the period, it will state the period of the hire. It will state the right of the owner to repossess. So what it means is that if the IRA refuses to make payments at some points, the owner has the right to repossess. The owner has the right to repossess. So I also want to ask you, because we have treated this, in a case where it is an illiterate who is a party, what should be there? What is the position of the law? I wish I have not done it here. What is the position of the law when illiterate is involved in hire purchase agreements or in any agreement, in any contracts whatsoever? What's the position of the law? I'm in slide 16 already, Ms. Rofiat. But I'm asking a question. In a contract where an illiterate is involved, yeah, thank you. It should be read over to them, and it should be they have to understand it. So Rofia said I should go back. I don't need to go back because all of this we have done it. That's why I didn't really mention it so much, okay? Okay? Okay, so that's for it. Thank you for all of the responses. So it also apply, hire purchase agreement is also a form of contract. Is a form of contract. So if an illiterate is also involved in hire purchase agreements, the term of the contract should be read over to him, and he should understand it. It should be signed by the person who had written it. Their name and address should be there. Okay? Okay, so let's start with obligations. What then is the obligation of the parties in hire purchase agreements? We are going to treat it as obligation under common law and obligation under Hire Purchase Act. So under the common law, the duty of the owner is expected to deliver the goods to the IRA, ensure that the IRA gets possession of the goods. And most of the time, if the breach of this, if before the item is being delivered, they would have sat down to agree on terms. They would have sat down to agree on terms. If after they have agreed on those terms, and at the specific time when the owner is supposed to deliver the item to the IRA, he did not deliver it, the IRA has the right to repudiate the contract. Because it's time start counting, except they draft another contract. So he has the right to say, come, we have agreed that you deliver this thing to me last year, December. You didn't deliver it to me. It can decide to repudiate the contract. So where the goods is delivered, where also in a case where the goods that they deliver, where the goods the owner delivers is different from the good they have agreed to, the IRA also has the right to repudiate. If we have agreed that you are giving me a Toyota, whatever, I don't know their names now and what they, okay, if we have agreed that you give me a Toyota 2006 and you gave me a Toyota 2004, the IRA has the right to repudiate, to say, I'm not doing this again. This is fraudulent. All right. Are we still together? Are we together?
Yes, ma'am.
Okay. So then the obligation, that's the obligation under Hire Purchase Act. But under the common law then has some implied conditions. There are some implied terms. One of the implied terms is that the owner has the title to it. That is, it is the owner that actually owns it strictly. It's not that it's not the owner. There are times that some people will be, they may not have finished making payments on their own too, or that is not even the owner, or that he assumes that is the owner. So, you know, why law always address all of these things is that at times you, in your mind, you will be like, but can somebody give out what he doesn't own? There are times that people do that. In fact, he may not even do it intentionally. But that's why the law tries to cover every aspect of life, so that if anything happens, the law will be there to protect an injured party. So under the first condition, under the first implied condition, it is implied. They may not even write it expressly. It is implied it is implied that this item you are giving to me under hire purchase belongs to you. All right. Number two implied term is that it is free from all charges or encumbrances. That means you yourself, that you are the owner. When you bought it, you must have finished making payments. There is nothing, there is no problem to that thing. Not that I would now be riding on the highway one day or be using that item and somebody will come up and say, come, the person that gave it to you is not the owner, hasn't concluded payment. All right. So that's the second. Are we on the same term? Are we doing well? That's the second implied term. The third implied term says that in the case where it does not possess the good title, the option given to the IRA to purchase the goods is of no effect. Right? So that means the owner cannot even give what he doesn't have. He doesn't have the title to that thing, so he cannot give it to the hirer. So the hire purchase agreement is of no effect. All right, that's number three. Number four condition under that says that in such case, the IRA can repudiate the contract. So if the title of the owner is defective, the IRA can decide to say, come, I'm not going ahead. I want to repudiate. I hope I will ask this question. I hope you understand that it's okay for him to repudiate. He has the right to say, I am not going ahead again. Because in fact, the owner doesn't have title to it. Are we doing well? So number 3 point says, so Olani, it depends on the agreement that they had written from the inception. If the agreement is on hire purchase, so be it. If the agreement is on sale of credit, so be it. It is the tone of the contract agreement that will determine what it is. Okay, Olani? Okay, so let's keep going. So number 3, the third point says that the owner has the duty not to interfere with the quiet and peaceful possession. So if you are giving something to somebody, you cannot then go back and be disturbing them on it. You gave a car on hire purchase house. On every morning they'll be seeing you. You'll be disturbing them. Where are you now? Where have you paid? And all of that. He has the rights to hold on to that, to possess that thing without any disturbance. Although it doesn't mean that if you're in agreement, you have written that I'll be checking the car every month, at least once in a month. Of course, you can have that. But when it now comes to you coming every day and disturbing him, you are affecting his quiet possession. It's just like your landlord. Of course, I hope you know that a landlord has the right to check his house at least once or twice yearly. But when he starts coming to your house every day to come and check the rooms, there's a problem. That means the person is denying you of quiet possession. All right. And so this also applies in hire purchase agreements. So if the owner, Adedayo says that if the owner has no title to the goods, can he hire it out still? If the agreement was that of hire and not hire? No, of course, if it's for hire, in fact, for that, I can't speak to that. I will not remember. If it's for hire, let's assume if it's for hire, of course, he can hire it out. He also may be under an hire purchase agreement and decide to hire it out to somebody, so that somebody else should use it just for him to make, let's assume he's sick, can also say, oh, can you use it for a while? Use this for a while and give me my money. That can apply, okay? What if the buyer spoils the product? Yes, all of this will be provided for. When you spoil the product, you are going to make payment for it. You cannot spoil it before. That's why I had said that he has the right to be checking on it, so that you will see when we get to the right and obligation of the IRA, so all of that will be cleared up. You guys you are trying to go forward before we get there. Don't worry, we'll get there, and all of that will be sorted out. So another implied terms is that the goods delivered shall be fit for the purpose. You know, and this applies in most cases when the owner is an expert. You know, for example, somebody that deals in car, a dealer in cars, he knows the strength of cars and all of that. And he wanted to give the car on hire purchase, or somebody approached him that, please, I want to start a Uber business. I don't have money. If you can give me a vehicle. But I want a vehicle that will be fit for the purpose of this, of a Uber ride. And most of the time they go for Toyota. I don't know if Toyota Camry or whatever that they go for, but most of the times, a lot of these Uber drivers go for Toyota because of its ruggedness. So let's now assume, and there are some Toyota that also doesn't consume fuel, all right? Let's now assume the dealer now gave the Uber driver a Mercedes-Benz. It doesn't fit for purpose. And so at that point, if maybe at the first month or second month, the IRA has been driving it and it consumes fuel, and getting the parts in the market has been very difficult for him, because it depended on the expertise of the dealer, he has the right to repudiate and say, come, I'm not going ahead with this contract again, because it doesn't fit the purpose for which I had asked for it. All right? Are we on the same page? So if we are still on the same page, let's quickly look at exclusion clauses. I know by now you know what exclusion clauses mean. It means a clause excluding somebody's liability. It's saying that I do not have liability, or come, or if anything happens, or I cannot be made liable for it for something. In the case of exclusion clause, the implied obligation of the owner of the goods can be excluded or modified by express agreements. Remember when we're talking about exclusion clauses, we said that exclusion clauses must be between the two parties. One person cannot say, but we should have known that this is the exclusion. No, you need to have told this person, if you need to have told the person that, come, I will be excluded from this liability. And it's until that person agrees before you can go ahead. If the person doesn't agree, exclusion clause will not go ahead. And also there are some times that some parties, they may not have done their own part of the obligation. they will be running after exclusion clause. Even if the exclusion clause, the parties had agreed to it, you know, and, you know, let's say, for example, somebody hires a car and the exclusion clause is that if after, okay, this says that the car that was delivered to him had the same plate number as the one he negotiated for, but was much older. I'm giving this example. In this case, the claimants, like the one I had, like what we have agreed to, like what I've explained, he went to a dealer shop, and at the dealer shop, they showed him, this is the vehicle we are going to be giving him. And in fact, maybe it has been registered in Nigeria. He has seen the plate number. And afterward, they delivered another one to him, which was old. All right. And the exclusion clause says that the driver will not be made, or the hirer will not be made responsible for any problem that happens or whatever. But then, in this case, something had happened. The person who had been unfaithful cannot claim for exclusion clause. That's where I'm going to. So if they have asked for a better vehicle, we gave them an old vehicle, you cannot claim exclusion clause. You cannot claim exclusion clause, okay? Are we on the same page? This place has been quiet. Our chat box has been quiet.
Yes, ma'am.
Okay, so let's quickly go ahead. Then what is the obligation of the owner under Hire Purchase Act? Under the Hire Purchase Act, the implied terms of the common law applies also under hire purchase agreements. Remember all the implied terms now: quiet possession, it is free from all encumbrances, that is okay for the purpose for which it is asked of. All of that occurs under all the implied terms under common law also applies under hire purchase agreements, under Hire Purchase Act rather. So then let us look at let us look at the section 4 subsection 2 of the hire purchase agreement. It says, it provides that where the hire makes known expressly or by implication the particular purpose for which the goods are required, there is an implied condition that the goods are reasonable fit for it. So remember, when we're talking about fitness of purpose, it doesn't really apply in hire purchase agreement or in Hire Purchase Act. All right. So what really applies here is merchantable quality. But what happens under common law? It is assumed that when somebody has told you that this is what I want to use it for, whenever you give it to them, it should be fit for the purpose. But the Hire Purchase Act never mentioned that. It never mentioned fitness of purpose. Okay? So reliance on the owner's skills and judgment is not required. So under the Hire Purchase Act, you cannot say, oh, but I went to meet you, but you are the expert in this field. I expect you to give what will be fit for purpose. It doesn't apply under the Hire Purchase Act. I think this may have happened because maybe over the years, people have been repudiating contracts based on slips on this kind of on this, someone's Dorcas. What is in slide 21 is what I've explained already under the common law situation. So I really do not want to repeat it again. All right. We said the implied terms under the common law situation also apply under the Hire Purchase Act. The only difference is the fitness of purpose. And so under the Hire Purchase Act, it never mentioned fitness of purpose. So you cannot rely on anybody's expertise under the Hire Purchase Act. Is that understood? So let us also look at the exclusion clauses under the Hire Purchase Act. Under the Hire Purchase Act, the implied terms it says that it provides that the implied time set out in section 2 cannot be excluded and it cannot be modified. So all the implied terms, nobody can touch it. It cannot be seen as an exception. You cannot say when we are talking about ownership of having the title, exception clause does not carry, there's no exemption as having the title. You must have the title. If you don't have the title, they repudiate it. Exception clause will not apply. Okay. So let's quickly go to okay, let's read. This means that where there is an exclusion clause in hire purchase agreement, it will not avail the owner from fulfilling its obligation as provided in section 4.1 and 2, except if the provision was brought to the IRR notice and its effect is explained to him. In other words, it bars the use of exception clauses except where the IRR was warned before the inclusion. Okay, just to clearly place that place clear for you. What it says that the hire purchase act, unlike the common law, it never provides for exclusion clauses. It's only when he has making known to the IRR that this vehicle I am giving to you, although we agreed to one before, I am giving you a different one. Do you agree to it? Immediately he agrees and says, oh, I agree to you. It cannot repudiate that contract again. All right. But then they cannot write in the hire purchase agreement that this is an exclusion clause because under the Hire Purchase Act. Okay. So then what are the obligations of are we on the same place or in the same, okay, wait. There's a question here. Someone say, which law is particular to lawyers follow? Okay, which particular law? Okay, which law in particular do lawyers follow in recent times? Is it the Hire Purchase Act or the common law? Because I realize that they are a bit different anyways, a good lawyer, now remember, they can do any of it. The issue that can happen, or the only place where you can then differentiate is where two people enter into an hire purchase agreement, but they did not write it down. Which law would apply there? In the case where they did not, I'm asking Agbona. Okay, Agbona Barry, I'm asking, okay, Agbona, I'm sorry for doing that. Isioma, what law will apply if two persons enters into hire purchase agreements and they did not write it down? Which law would apply? Isioma, I need your response. Which law will apply? And not just Isioma, I need everyone's response. Beautiful. You know, most of the times, we have noticed people that are, what people does is, whenever they want to enter into an agreement, they will not say anything to lawyers. You are expected to contact a lawyer in anything that you want to do when it has to do with you signing papers and then making yourself liable to things. You are expected to involve a lawyer, but people don't want to pay lawyers. You are like, but I know it now. I did it in school. Yes, you did it in school. You are expected to just know the basis. But then it's good to approach a lawyer. A good lawyer, in fact, all lawyers will ask you to write it down. And immediately it is written down, it will be protected under the Hire Purchase Act. But if it is not written down, then you have no option but to subject yourself to common law. All right? Except in situation where equity will come to your aid. All right? So what then is the obligation of the hirer? The IRS has the obligation to take delivery. If you have entered into an agreement, you must take the delivery. It's not after 2 days, 3 days, you now rethought, you now had a retain that, but I don't want to do it again. Except you have been able to contact the man and you also agree and discontinue the contract. But you cannot just discontinue without the other person agreeing to that. Another obligation is to deal the reasonable care of them. That's a question somebody had asked before. Immediately the hirer is in possession of an item, you are expected to take reasonable care of that item. And you mustn't deal with it in a manner that is not good. You can't be driving recklessly. You have a fan, they gave you a fan to you, you'll be offering it, you'll be doing whatsoever it is. Okay? And so on and so forth. The next one says, the hirer has the duty to make instrumental payment promptly. You must make your payment on time as at when due. Let's say, for example, if number 4 says, if you didn't make that payment as at when due, in most hire purchase agreements, they used to have some clauses that says that, oh, if you did not make this payment at this time, you be getting additional payments, maybe additional 2,000 naira, when next you are making the arrears of payment. But normally, there's if it is the owner rights generally in law, immediately you did not make payments, the agreement terminates. That's the general law. But there are exceptions where the two of you had agreed that, come, in case I did not make payment as at when due, because anything can happen, can you give me 2-3 days extension to make payments? If after that 2-3 days I didn't make payments, can you allow me to make additional payment, make maybe 2,000 naira additional payment to it? But then afterwards, if I didn't do all that, and after 2 installments I didn't pay you, you have the right to come and take your thing, or you have the right to take possession back from me. Are we on the same page, please? Are we doing well? With this, I've explained. Are we doing well? The rights and the obligations of the hire. Okay. Okay. I think. Then let's look at remedies. What are the remedies available to owners? One of the remedies is, in the case where the hire breaches the contract, number 1, at common law, the remedies that usually available to the owner when the hire breaches the agreement will normally be determined by their agreement, what they have, maybe when they were making their oral agreement, or maybe written or whatever. When they are making their oral agreement, most of the time they may have said some things. Right? So an owner may insert a minimum payment clause, like I said. You must say, oh, this is what you pay at this time. If you don't pay after 2 installments, then I will come and collect it. I'll come and repossess the item. So he had the remedy. One of the remedies for him to repossess the item in the case where the instrumental payment isn't made. They may have the agreement that if I didn't pay after 2 months or 3 months. So it is a clause. The clause says that the hire will pay an additional sum, like I said. There may be a compensation for for him not paying on time and all of that, like I had earlier mentioned. Another point is that the owner can sue for damages. All right. So where the hire refused to take delivery, remember we mentioned delivery, that he has the obligation to take delivery. Delivery means if after they have written the contract and then the owner then takes the car or whatever it is to the hirer, and the hirer refuses to accept it. Under the law, the owner has the right to go to court for damages. That for you not accepting this thing from me, you are going to pay damages. Or where the hirer terminates the contract after taking delivery. The owner also has remedies for breach of contract. I mentioned 2 things now. I said number 1, if he did not accept the items for hire, the owner has the right for damages. Number 2, even after he has collected it, but later he now said he's not doing again, even after, maybe after 1 month or 2 months, the owner still has the right to ask for damages, because of course, he would have returned the item back to him, and then he has the right to take for damages. Where are we exactly? We here? Okay. So there's a clause that said, please remember that the hirer has the right to terminate the agreements and return the property to the owner at any time before the final payment is due. But under the Hire Purchase Agreement Act, it provides that this must be done in writing. The question now is that what happens when they terminate the contract? What I'm saying is that someone said they don't understand. Let's assume under the Hire Purchase Agreement, the IRS still have a right to say, I'm not going ahead again. He can terminate the contract. But if he terminates the contract, what we are saying is that the owner of that item has a right to sue him for damages in case he hasn't paid the installmental payments that he ought to pay. Remember, it's an hire. But under the Hire Purchase Act, it says if an IRA must terminate a contract, he must terminate it in writing. He must write it down that, come, I'm not going ahead with this thing again. All right? If after he has terminated the contract, okay, if after that, the problem that we may have is that what then happens? Number 1, under the common law, the owner has the right to sue for damages. Okay? Under the Hire Purchase Act, Section 8 says that the IRA terminates the agreements. It will only be liable to pay the owner the sum that will be sufficient to bring this that will be sufficient to bring the sum to half. Now, I will explain so you can understand. If under the common law, the IRA terminates the agreements, the owner of that item can sue to court for damages. But under the Hire Purchase Act, the Hire Purchase Act saying you really don't have to return it. You don't really have to go to court. Just ensure that if the total amount is 2 million naira, the IRA who want to terminate the contract must have made 1 million naira payments. At least make payments, half payments to the owner before you can terminate. And if not, that means you have done wrong. And so further thing will follow. If you have refused to pay, then of course, the person still have to sue you to court. Do you understand what I explained? Do you understand my explanation? This your yes is becoming so slow. So Section 3 says renders void any provision in any agreement that restricts or excludes IRA's right under. So look at this under this Section 8. Yes, I'm still talking about remedies. So I am still under remedies. Olayinka, I am still under remedies. These are the remedies that's available to the owner and the. So here, under this Section 8, the owner cannot do anything outside of this Section 8. You only have to succumb to what the law says strictly. So what then are the right to repossess or to retake the goods under common law? We are done. I'm just on the 27th, right? Okay. So under common law, the common law thing is very nice and straightforward. Under common law, an owner, I know you have another class, I'm done. So under common law, an owner has the right to repossess the goods where the IRA commits a breach of contract. That I have said all of that. In fact, under common law, if out of 40 naira, here I said, if out of 50 naira, the hirer has paid 49 naira, but he cannot pay the remaining 1 naira. Under common law, the owner has the right to repossess the item back. He has the right to repossess the item back. So what then is the right of repossession under the Hire Purchase Act? And the one that really speaks to it is Section 9, subsection 1. It provides that where a relevant proportion of the hire purchase price has been paid, the owner can only repossess the goods by instituting an action. So this doesn't apply. What we are saying here is that if the sum in contention is 2 million naira and the hirer has paid like 1.5 million naira, you cannot just do it without going to court. Unlike what I said, if they haven't paid up to half. If they are paid more than half, in fact, it's almost going to the end of the payment. Before you can repossess, when the hirer defaults, you have to go to court before repossession. Okay? So also you have to look at the relevant proportion has been defined. The half payments of the Hire Purchase Act, okay, and where he has made 3/3 payments. You know, when we remember when we say about half, when he has made half, he can decide to repudiate and there will be no problem. You don't have to make you don't have to go to court. But when he has made 3/5 payments, in that case, you still have to go to court, okay? So, so where the owner contravenes the provision of section 9 subsection 1, the agreement will be terminated and he will be liable to refund the hirer. So what it means is that if the person had made payment of maybe out of 2 million, he had made 1.5 million naira, and because he has not been able to make the other payments, the owner cannot just go to his house to go and repossess. He has to go to court. But in the case where he now go to court to repossess, then the hirer can go to court and there is probability that the owner can refund all that the hirer has paid, you know. Okay, so our last slide, this is the last slide and almost my last sentence. It says that under section 9, subsection 9, subsection 9, subsection 3, the owner can remove the goods in the case where the defendant, or will I say the hirer, has made like a large amount of payments. The owner can try to remove the goods from the possession of the hirer, and this he can do by going to court. He cannot swarm to all by himself go and remove it. And the reason why the court allows him to ask for removal is that, you know, by the time the hirer keeps using it, the item will be depreciating and he may not be paying. So the owner can file an application in court. That court should please help him remove that item from the possession of the hirer, pending the termination of the case in court. Okay? And really, we have come to the end of the class. For those that are going for their classes, I wish you are able to ask some questions for me. But then, in the next 4 minutes, if you have any question from me, please, you can ask your questions. You know, when I was trying to explain that very initial part, I wish I hadn't taken that much time. But then, I hope I've not rushed you towards the end of the class. Okay, Blessing, you can ask your question, please. You can ask your question, Blessing. Okay, unmute yourself. We can, for Blessing, if you have a question, please raise up your hand. Blessing, you can unmute yourself if you don't want to write, but if you want to write it down for me. For those that have questions, you can still raise up your hands.
Good afternoon,
Good afternoon, ma. Good afternoon, ma.
So Blessing, okay.
ma. Okay.
Blessing did not ask a question. Okay.
Good afternoon,
Njideka, please
ma. Can you
unmute
hear
yourself. Is the relationship between supply and buyer and so.
Oh,
Yes, it's also, yes, thank you. Any yes, it's also the relationship between supplier and the hire is also buyer and seller agreement. Yes. Yes, it is. We are just trying, yes, it is. Emily, it is. But remember, we said that at some points, the sales of goods act also applies. So it is in that case when it has to do with buying and selling of goods, it applies. So the person that has unmute themselves, oh, sorry, sorry. Let me do what I've done. Okay. Then I can hear you now. I haven't been hearing you. Please, you can come back. Come again. Repeat what you've said,
ma? Can you
please.
hear me now?
Yes. Thank you. Is that
My question
Blessing?
is,
Is that Blessing?
yes, this blessing.
Oh,
Yes,
okay.
ma.
Please go ahead.
Yes, ma. Yes, ma. You said something about ownership, dealers and finance company.
Yes.
Then I have a question. In the case whereby the owner now the dealer, the finance company financed the dealer to buy the goods from the owner, and then the dealer now went into an agreement and hires to another person, which is the hirer. What happens to the previous owner of the goods? What contracts, like, is the contract being terminated, or what
Remember,
goes
the
on
finance
after?
home will have given the owner money, and the owner is gone. That's the essence of the
Okay,
finance home. The finance home is meant
okay,
to pay. So the finance make outright payments. And so the owner is out of that initial owner is out of the picture. Is that clear?
okay. Yes, ma'am. Okay, which means the contract has ended like that.
There is no that thing is not, it's just like you, Blessing, right? You are like, you sell cars. Somebody came to meet you. Why I'm trying to, in fact, most of the dealers that I'm talking about, they are those that sell cars. Those people that sell cars. They are mostly those, but because they may not have the turnover, they try to involve a finance home. Now, this vehicle that I have some people that are interested hire purchase agreements. But I cannot wait till 2 years that they make payments. I have to take care of my home. I don't have enough cash. Finance home, please come and finance me so that I can give this person the car. So the finance home will now give them the dealer the money so that the dealer can have a turnover. That is where we mentioned the financial constraints. Okay, so even if the dealer is not the owner of the car, let's assume that dealer or the supplier bought it from somebody else. The money that he got from the finance home, he will use it to offset that, and that is gone. The relationship that will be left will now be between the finance home, the supplier or the dealer, and the hirer. But it is not in all cases that you need a finance company. There are times that you, Blessing, you can have your money and like, oh, this money that my grandma left for me in her will, I want to start a business on hire purchase. Then maybe you just bought 10 cars with your money outrightly and gave it out on hire. In that case, you don't need anybody to sponsor you or to finance you. In that case, you don't need a case of, that one doesn't involve an IRA. It doesn't involve a finance home. Sorry, please. That case, in your own case where you bought it outrightly, it doesn't involve a supplier. It doesn't involve a finance home. It's just between you and the hirer. And also, you expect the hirer to be a guarantor. All right? Do you understand, Blessing?
Yes, Yes, ma. Thank you,
Okay.
ma.
You're welcome. So you can unmute yourself. So if you have any other question, oh, there are some questions in the chat box. Okay, somebody said, must it be used for commercial purpose alone? It doesn't really have to be used for commercial purpose alone, no. But you just have to be ensure you are making payment though. It does not really have to be used for commercial purpose. It's just that what we have noticed, what has been the norm, what has been the norm so far is that it has always been for commercial purpose. And the reason is because if it's for commercial purpose, whoever that is giving it out for you, you'll be rest assured that if you are using this thing for business, there's 100% 100% guarantee that you give me my money because it's on business. But if it's something that you are using for your personal use, something may happen to your business, to your own finances, and you will not be able to pay back. So most of the time, people that enter this hire purchase agreement, they will enter into it with you because they know it's on business and you will be getting money from it. And so they, the fact that it's business will give them the assurance that you'll be able to make the payments. So please, we have to, yes, you can go. If you want to go, there's no problem. Just want to ensure that I'm clear. Okay, have a wonderful time. Bye.
Excuse me, ma.
Okay, do you have a question?
Yes, ma.
Okay, please quickly ask your question.
Okay. Yes, ma. My question is that though I understood everything you said, but I just want to clear this. The fact that under hire purchase, the payment is instrumental. So like now, after the last, let's say maybe the agreement is that the hire should pay a sum of 50,000 every month, like to make it complete. So like after paying the last installment, so like the contract is already, like it has come to an end. Then the item that is being hired, like it goes back to the owner and the hire goes on her way. Like is that it? Or then if
Okay.
the hire wants to own it, she has to pay the nominal, or after paying the last payment, the hire becomes the owner,
Okay.
or she has
So,
to pay the nominal payment.
okay. So, this is what I want you to get. When I was explaining that thing, the nominal payment, it is not in all hire purchase agreements. You remember that nominal payments will be involved. Everything boils around their agreement, what they both had agreed to in their contract. Now, in some cases, they will write in their contract that it is after you have made all this instrumental payment, you can take the thing. And some people can write it in their contract that you don't take it immediately after. After you have made all the instrumental payments, then you now put additional nominal payment of like 20,000 naira before you can take it. So what I'm saying invariably is that it is not in all cases that this issue of nominal payment is involved. It's only involved when the both parties had written that down in their agreement. But then the IRA has the option. He may decide to say, come, I'm a big man now. I don't need this car. Take your car. I've finished my payment now. And he can also, in the middle of the contract, after he has made half payments, that I'm not going ahead again. Because remember, it's a contract of hire. I am not doing again. Under the Hire Purchase Act, it says you must have made half payments. Under common law, it says at any time, you can decide to say, I'm not going ahead. It's just that the owner will sue you to court for damages. So Chisom, is that Chisom that asked the question?
I was the one, ma. Thank you, ma.
Okay,
That's
so
clear,
it's Adijat. Do you get me,
ma.
Adijat?
Yes, very well. Thank you, ma.
Okay, so is there any other question? Because
Yes,
lots of your colleagues. Okay, let's hear you too. Who is that? That's Chisom, right?
no, Miss Soma.
Okay, so this is what we are going to do. If you have any question, please raise up your hand. Every other person, please mute yourself. Miss Yoma, you can unmute, but the others, please mute yourself so that we can enjoy the remaining of this class. if you have a question, please raise up your hand. So, Miss Yoma, you can go ahead.
Okay, I wanted to ask for like the methods that the finance company can use to finance the hire purchase transaction, like ways they can use to finance it.
Okay. So, like, for example, finance is just like, they will give the person money now. They give the hirer money. Do you understand? If the hirer is the one that has the vehicle in the possession, they give it to him. But if there's somebody else they have to go and buy it from, the finance home pays the money to the person who is maybe the seller. And the hirer then the owner, the finance home becomes the owner. I'll repeat again. The finance home buys the item, pays for the item, right? So the way they pay it, I don't know, they may pay maybe by transfer or whatever, but then they'll be the one that will make payments. So they'll make outright payment. They will give the whole amount of money to whoever is giving out the vehicle. So in that case, it's like the finance home will then buy it. You know, when you buy something, you go out to buy something, that thing belongs to you. So at that point, the finance home becomes the owner of that thing. But remember that they bought that thing because the hirer came to them and gave them his word. So they will not let the hirer go because it is the hirer that will guarantee that they will not, it's the supplier that came to them. So they will not let the supplier go. They will ensure that the supplier enters into a recourse agreement, number one. And it also, most of the times, is also a guarantor for the hirer. Okay, so the finance home can buy it outrightly, or they buy it outrightly. They finance it, they pay money. Mercy Oma, what do you think about my response?
Yes, ma'am. But like, so where does the hire purchase stocking and block discounting come in?
Where does the what?
Hire purchase stocking.
I don't get that question again.
Like I read somewhere that one of the methods that the finance company can use to finance a hire purchase transaction is through hire purchase stocking.
Maybe that, of course, that's for the finance home. It could be
Yeah.
stocking that they will be updating on how to update. How do we get this money? That's their method. Do you understand? It's just a method of them retrieving their money back or how they do it. Miss Yoma, are we on the same page?
Yes, ma'am.
All right.
Thanks.
You're welcome. Okay, any other question? Okay, I think we have another question here. Onyedi Kachi, do you still have a question? I think we have attended to blessing.
Yeah, I don't have a question. I just want to clear something.
Okay. Okay, can go ahead.
Yes, you answered my question, and I wanted to be sure that I got what you said correctly. So now you said that the dealer buy from the owner, but the finance company finances them to buy the products. So now the
Yes.
dealer and sort of so the contract is not between the dealer, the finance company, and the buyer.
I
So
didn't get you
basically,
very well. It seems a friend of yours is obstructing our class or interrupting our class, rather.
but can you hear me now?
Now, better, yes.
Yes, I said that. So for me to get what you said right, so I want to know if I got what you said right. The dealer
Okay.
buys from the owner, but the finance company, they are the ones that finances them to buy the products. Then the dealers will now go and sort out for the hirers. So basically, the previous owner was not in any contract with anybody. So the contract is now between the dealer, the finance company, and the hirer. Is that what you mean?
Yes, will now be between the finance company and the hirer. Blessing, clap for yourself. And not just that. Remember, like I said, it doesn't mean that the dealer is out of it all. No. Remember, he will enter
Yes, ma'am.
what agreement will they enter with the finance company?
Because
Lesson, clap for
Because
yourself. That's just it. And that's just it. So, Miss Yoma, this talking you are talking about, is it STALKING?
No, ma. STOCKING. Stocking. Like
Oh,
stock.
hold on, please. ST,
OCKING.
okay, stocking.
Yes, ma.
But of course, I think that is to give them, to stock things in for them. Okay? They purchase the good. Okay? Stocking means that the finance company is like the role of the finance company. The finance company, they purchase the good from the manufacturer. Okay? And after they had purchased the goods, remember, they will purchase the good on behalf of the hirer now. And the hire it's just the method that they take. They can buy the goods from whoever from the manufacturer. And that's what we have done. We have been saying so far. They buy the goods for the hirer, and then the hirer start payments. But that means that doesn't stop the guy in between from being there. He still have to be there. Okay, he still have to be there. So I think we are good to go, right? That has bring us to the end of the class. Do we have questions? No. So if the hirer decide, okay, wait, I'll come. Summarize. I'm trying to read a question now, and there are a lot of questions here. But if any of you can still wait, the dealer buys. Is this person trying to talk about the stocking? Oh, okay. Okay, Miss Yoma, I don't want you to go back confused. Stocking is as good as what we have explained. The finance home pays the manufacturer. The manufacturer then gives it to the hirer, and the hirer continue paying the money to who? To the finance home. That is stocking. More or less like they stock the shop of the hirer, who is seen as a retailer. They stock his shop. They give goods to him. Now, it's now assumed that it is the finance home that stock his shop. And so he will be paying back to the finance home. Miss Yoma, I don't want you to go back confused. That's why I keep going back to you. So someone says the dealer buys, you're welcome. The dealer buys, the dealer buys from the owner, but the finance company finances them to buy the product. Then they sort out, yeah. So basically, these children, some people still coming in. The prison wasn't in any. Yeah, they are not in any contract. Thank you. Bless. Oh, it's Blessing that is still trying to say. So why do they include the nominal sum if it isn't a compulsory act? So, like I said, the law likes to cover all things. The fact that they mention it, if the law is even giving you an option not to do it, isn't it a good thing? But the law is saying in case an owner now says nominal, you have to pay nominal sum. Some people should not say, where are you now bringing in your home from? If it is that you pay instrumental payments. It's just trying to cover all the things that needs to be covered, okay? It's based on the agreement, yeah. I think I can go now. I think we are good to go, right? Yeah, you guys have done so well. And for those that are not able to listen to our last part, I hope when you have discussions, you'll be able to clear things with them. So enjoy
Sorry,
yourself.
my last question, ma.
Hey, Adeoye says, if the buyer decides to stop, it says he's no longer doing the hire purchase. Will the owner pay back the money the IRA has paid? Hold initial deposit. No, he's not paying anything. No. It's the person that decides to opt out that will forfeit it. No, if the IRA has made payment before, I'm talking to Victor, Adeoye Victor. If the IRA has paid before, there's nothing to take again. You are the one that say you don't want to do it again. Then you bear your loss, right? Okay. So,
Please excuse me, ma.
wow. Okay,
Sorry.
Adijat.
Okay, ma. What I wanted to ask is that
Okay.
after the dealer has brought the IRA to the finance company, is it the finance company that is going to pay the dealer, or like who is paying the dealer? Like, how is he going to profit from the?
Yeah, it's the finance company now.
Okay.
They will enter their own agreements that this thing
Probably.
that. But you know what? I also want you to I want to clear something for you also. In most of the times, these dealers, if you are going on this Yaba and Ikorodu Expressway, you're always seeing these people that sells vehicles. These are the dealers. So in most of the times, they are the ones that are selling the vehicles. So what the finance house do at times is that the finance house give the money to them. So they will know how to calculate their own interest. But in case where it is another third party, where the finance company bought from, of course, the finance company will enter a different agreement with the dealer, okay? With the dealer or supplier. And so they will know how to get he will know how to get his interest and all of that. Thank you. Bye.